What's up, everybody? We're back into the wild world of the YSL trial. Will these prosecutors be booted from the case? The defense attorneys continue to ask because there continue to be more and more problems. Ex parte hearing after ex parte hearing, Brady violation after Brady violation, new information they didn't know about, disparaging remarks made back and forth. But the new judge seems like she's laying down the law, cracking the whip a little bit, and maybe giving us an indication as to how she's going to deal with this. So much is happening. We're going to get to absolutely as much of it as we can today. I'm sure we won't hit every single thing because there will be more for another time, but we want to answer your questions. So let's get into it. It's been one of those days where basically every single thing has gone over and taken more time than I expected, but we're here a few minutes late. I appreciate everybody hanging and waiting. But I've got my dad here with me, and to kind of set the stage for these clips that we're going to watch, it's over the last 2 days, and even more has happened today. We'll talk about and we'll recap. Documents have been filed, motions have been filed. We'll discuss some of those as well. We're not going to be able to watch every minute or read every document on this stream, but hopefully we'll be able to answer all your questions and have some idea of what the context is that's going on, because literally every time I get on Twitter, people are tagging me in other clips where crazy things are happening. And it's all mounting to these lawyers asking to disqualify the prosecutor and have the judge declare a mistrial in this case. So from our perspective, what is kind of your overarching thought before we get to the clips as to what all this chaos looks like and means compared to a normal trial?
Well, it is not a normal trial. I mean, I think it's been going on 19 months. I mean, from the time the jury started being selected to now, I think we've gone about 19 months. And so that's the longest trial, from what I hear, in Georgia state history. So nothing is normal about this case. There are so many motions and so many things that go wrong, and some of these things go wrong in every trial. But the fact that all of these things have gone wrong in one trial, that's the unusual part. These guys must be sitting up nights, writing motions every night. They've got to be doing research every night. The state prosecutor's office has to be doing the same thing. I just hope they're getting paid enough, because they're working their butts off.
I assume you're talking about the defense attorneys. The prosecutors get paid or they get paid.
Well, that's true, but I'm just, yes, as far as pay goes, yes.
Yeah. Yeah. So I think that when we look at this case, it's a situation where lawyers have certain candor with the court, and they're cordial with each other and usually respectful, and at least act respectful in front of the cameras or in front of the judge. That has seemingly just gone out the window in this case. And we're going to see some clips today where the lawyers are like, I've never done this before, but I can't believe a word that's coming out of their mouth. And if I can't do that, how am I supposed to continue trying this case? But the first lawyer we're going to look at, and the first lawyer that we're going to put up on the screen, is Kayla Bumpus. And we're going to hear testimony under oath from multiple lawyers, from the witness stand and from the podium, proffers and testimony about what happened in these ex parte meetings. And in Bumpus's testimony, we're going to listen to a few clips of the judge is asking her about things that she said on her own YouTube channel and what she means, and is that what she actually meant? Let her explain herself. So this is unusual in and of itself as to the process and procedure of how this is working. So let's start out and we'll listen to this first clip of Kayla Bumpus on the stand.
Wait, Judge, can you step out?
Who is the she that says, wait, Judge, can you step out?
Simone Hilton.
Okay, ask the judge to step out. At that point, does the judge step out?
Yes.
Does anyone else step out?
I don't remember if the court reporter stepped out, but I know she stopped taking down what we were talking about.
Okay, and she may or may not have remained in the chambers.
Correct.
Okay.
And so at this point, you're saying that the judge is out, you, Ms. Hilton, Mr. Copeland, 4 sheriff's deputies and 2 DA investigators are in chambers.
Yes, Judge.
Okay.
Okay. Next step. What happens next?
P.S. This judge jumps in and asks a lot of questions, which I think is interesting because you can see where she's focused.
Simone starts to talk to Mr. Copeland about, I guess this is the part about purging yourself and perjury and impeachment.
Okay. What specifically did Ms. Hilton say about purging himself?
About purging himself once he began to testify that he would purge himself of him being arrested.
Okay. What about perjury did she tell to him? Did Ms. Hilton say to Mr. Copeland?
I think some of this is on the transcript, but she reiterated the fact that pretty much she wanted him to testify. She didn't know what he was going to say, but there was one thing that they know that he didn't do that she would not allow him to testify to.
Okay. What did Ms. Hilton tell Mr. Copeland was the one thing he knew? She
All right,
knew.
let's not assume any of this because this is your witness, so don't lead her, okay?
Okay. So when you say that, what did Ms. Hilton specifically say regarding that?
Well, first, Mr. Copeland said, I can claim all of this. I can claim all of this. I might as well just say I did all of this. And she said, well, we know you didn't do all of this. And specifically, we know you did not kill Donovan Thomas. And I will not allow you to get on the stand and say that you killed Donovan Thomas.
And when Ms. Hilton said, I will not allow you to get on the stand and say you killed Donovan Thomas, did she say anything else with respect to that?
Pretty much, I was explaining to Mr. Copeland about independent evidence because she said if she had any independent evidence to prove that he was lying about anything, she would just use his statement to impeach him. But she would not necessarily press charges against him for perjury. But she said that if he said this thing, this one particular thing, which was the unaliving of Donovan Thomas, that she may move forward with perjury. And Mr. Copeland says, well, it's not just about me knowing who killed him, but it's about, I know more about that infinity, and I know something about somebody who's not even on trial.
Okay, I'm going to stop you there a second because there's a lot to unpack, okay? So do I understand your testimony to be that Ms. Hilton said that she would prosecute him if he lied about the killing of Donovan Thomas, but she would not prosecute him if he lied about other things?
Yes.
Let's go back to the infinity because I didn't catch all of that. What did Mr. Copeland?
And again, the problem with that is picking and choosing exactly what you're going to prosecute somebody for is tailoring their testimony to what you want it to be and using your police power as the state attorney to force certain testimony and prevent other testimony.
Say about the infinity?
You just say, I know something about the infinity that y'all don't know.
And how did Ms. Hilton respond to that?
No, I don't remember, but basically she's just like, okay.
Okay. What happened next in that meeting? Oh, can I stop you a second? Had Judge Glanville re-entered the chambers where you were at this point?
No.
Okay. Please continue. What happened after the comment from Mr. Copeland about the infinity?
I think that, I mean, she really didn't say anything about it. She just kept moving forward with explaining to him about she wasn't going to go for that lie about the unaliving of Donovan Thomas, but whatever else you lie about, I'll just use it as impeachment. And that conversation went on for about 5 minutes or so, maybe a little bit more. I don't know. At this point, we've been in there for 2 hours. And
all right. So anything you want to say from that clip before we jump to the next part? We're going to jump ahead a little bit.
You pretty much said it when you said that they're picking and choosing what they're going to charge perjury on. Everybody has to remember, only the state can charge a crime. So even if he committed perjury and the defense knew he committed perjury, they couldn't do anything about it if the state wasn't going to prosecute it. So he can lie, and we all know Mr. Copeland is a habitual liar. He can lie all he wants, and the state's already told him they're giving him a free pass. And remember, all of this conversation happened outside the presence of the judge and without the court reporter taking it down, even though the court reporter may have been in the room.
Go ahead, Mr. Steele.
Thank you.
Now, this is Mr. Steele asking her questions.
Good morning.
good morning.
Counselor, was there a time in your presence that you heard someone give a direction for the sheriff deputies to shut off their body-worn cameras?
Absolutely.
Do you know who gave that direction?
Deputy Brown.
And do you know at what period of time or what point in time that occurred? Were you alone with your client? Was it throughout the whole time? Were you with Ms. Hilton? What was going on when you heard that?
That was the first thing he said when the deputies brought Mr. Copeland in.
So as far as you know, I'm not saying the sheriff deputies filed that order, but they were ordered to turn off all body-worn cameras as far as you were concerned.
Yes.
And this conversation that you just relayed to us with Ms. Hilton, you and Mr. Copeland, your client, was that a calm conversation? Was it heated? How would you describe it?
It was, we had been in there for 2 hours. It was a high level of emotional tension, if that's a thing.
Okay, were people getting louder than we're speaking now?
Yes.
And who was that?
So it kind of gives us like an idea of what the vibe was there. Yes, we watched the YouTube clip, broke it down together, figured out what we could learn and what might come up later, which it has. How can they give immunity for everything he's saying except for the death of Donovan Thomas? Is this allowed? I would be confused too. So they can say we're going to give you immunity for crimes, but not if you get on there and intentionally lie and perjure yourself. They can say that. That happens in almost every immunity agreement, that this goes away if you lie on the stand, right? but it's different when you're taking specific instances and saying, you can say whatever you want about this, but not what you want about this. You can confess to this, but not that, because if you confess to that, it makes our life harder, makes this trial harder. You can't tell witnesses what to do and how to do that, even though like we all sit here together and we think we know what the truth is. We don't really know what the truth is because we weren't there. So if he's going to say he did something, how can you be absolutely positive he actually didn't do that? You know, and that's kind of the issue that comes up.
Well, everybody has to understand that he's going to be, hypothetically, even though he's a mess, a state witness. So the state is going to call him. When they call him, a jury looks at him and says, okay, the state's vouching for this guy. They're putting him on the stand. If he says something that weakens the state's case, it goes a long way to putting doubt in a juror's mind. So the state wants to make sure he says exactly what they want him to say and nothing else, and make sure that they don't say, oh, you lied. They're not going to accuse him of lying, and they're telling him that.
Chris K said, Mr. Tragos and Peter, thanks for covering this. I have to admit, I thought she was not well prepared. I would think a lawyer involved in this situation would have made copious notes about it and after it happened. Yeah, I don't know. It was a little bit, I don't know if she was nervous or what. It was a little bit disjointed to me, but I also think that she was careful in what she said at certain points. And we're going to watch another clip. I think that's going to add to that. Renell said, hi, Peter, trial is 19 months. What happens to the jury's job? While you answer that, Dad, I'm going to find the next clip.
Okay. Well, at least in Florida, there's a law, and I think there's probably one in Georgia, that they can't be terminated from their job while they're on jury service. So they have to keep the job open, although they get paid a jury salary, which is a pittance, probably compared to what they regularly earn, but their job has to stay open.
Yeah, and they just keep going. They just keep going with their job, basically, whenever they can, when they have breaks like this. If possible, they just go back to work. Chris K said, and I didn't like how she kept saying unalive. She wanted a clean clip for her YouTube channel. Oh, it's an interesting thought.
Well, apparently the word unalive, again, I'm a little older. Apparently that's become a common word now that they are using.
Just like generally?
As opposed to the other words that we used to use for homicides and things like that. Apparently unalive is a common vernacular now.
So I know it's a YouTube thing, obviously. I did not know it was a common vernacular.
Right. I
Cool.
understand that it is.
Interesting. Okay. Interesting note. All right. So here's the next clip we're going to watch.
Okay, but if he says he don't recall to everything, he'll be okay.
Okay. Okay. So at that point, between, whatever you said, 47 and 51, y'all are back on the record, right?
Yes, Judge.
Nobody's like declining to take down what you're saying.
No, Judge.
Okay. So anytime during that point in time, do you say, let the record reflect that Ms. Hilton, Mr. Copeland, and I had an off the record conversation, and I'd like to put on the record what was said during that conversation?
No.
Okay.
So this is the judge who's very smart in cracking down and getting into, if people are saying this transcript's incomplete, if they're saying something nefarious went on, why did nobody stand up and say anything in the hearing? And if it did happen, now's your chance. What happened? What was wrong? What's wrong with that? And again, the wink, wink and stuff that we heard, it was not complete. There's stuff in there that, wasn't transcribed. We've heard some little inklings of that, but never really what it was or what the big deal was. And so now it's starting to trickle out a little bit. Now we found out there was another ex parte hearing that was kind of referenced and some other stuff that we kind of knew something else must have happened. But this is more about what was not transcribed that was said or done at that hearing.
And I think you need to listen carefully to the judge. Without the judge actually saying it, she's very critical of Ms. Bumpus. And so listen to how the judge is asking those questions and asking her, well, did you do this? Did you do that? And you can tell in the judge's tone that she didn't really like the fact that Ms. Bumpus didn't do these things.
Well, I don't know if it's that she didn't like that she didn't do those things. I think it's that she didn't like how afterwards she acted like there was a problem, but in the moment didn't bring up the problem, which is
right. Well, didn't raise it with the court. She thought that Ms. Bumpus should have raised this with the court, and she didn't raise it with the court.
Right.
And also on page 51, I say, are you saying you want to get up there on the stand and say something?
Uh-huh.
And then it's no response. He just looks at me.
Okay. All right. So does 47 through whenever that last page number was, does that accurately reflect whatever was said during the alleged off the record conversation?
It doesn't accurately reflect, but it does. I do try to mention what we talked about, but it doesn't accurately reflect everything that we discussed.
All right. So was there something else that you discussed that you should have said, oh, and by the way, this also happened that you didn't say?
I'm confused, Judge. What do you mean that who didn't say? That
You.
Simone didn't say?
No, anybody during the alleged off the record conversation, when you're
She's like, if you thought this was a problem, which it seems like some people in the courtroom think it was, you didn't say we need to make sure this gets on the record. I think what the judge is pointing out is it was appropriate to have this off the record conversation with her client privately.
making this record after y'all go back on the record, you said it still wasn't accurate. And you also said you weren't stopped from saying anything during that part. So what is it that you should have said that you didn't say?
Well, I guess the only thing that I should have said that I didn't say is that Simone said that she would not prosecute or move forward with any type of perjury if he said anything except for the unaliving of Donovan Thomas.
Okay. All right.
And that's important.
All right. So when is it that you actually reviewed and read this transcript?
I really don't know. I think maybe around the time that I had to retain counsel, I think we reviewed it together, which I cannot tell you the exact date, but
Sometime in late June?
yeah, somewhere after 6/12.
Okay. And we all in this room know this to be the case, but you are an attorney licensed and barred to practice in Georgia, right?
Yes,
Okay. And as such, you have a duty of candor to the court.
yes, Judge.
Okay. Is there any point in time after you read this transcript and thought to yourself, wow,
So those background questions were setup questions, like you're saying.
is there any point in time after you read this transcript and thought to yourself, wow, that really doesn't include everything, that you brought it to this court's attention that the transcript was incomplete?
This court, well, there really was no court's attention to bring it to, because after all that happened, it's been on recess for so long.
So you've been in court when we've been in session for the last week or two, right?
Yes.
Okay. So I was presiding at that point in time, right?
Yes.
Did you at any point bring to my attention that you believed as an officer of the court and a participant in this ex parte meeting that the transcript did not accurately reflect what occurred in that meeting?
Well, Your Honor, I did not bring it to your attention, and I honestly still would not, as an attorney, if I can answer this as an attorney, I believe that there is some value in off-the-record conversations for specific things, and it has always been my position, even in speaking with members of the defense, that as far as anything minus the off-the-record conversation, that the transcript is complete.
Okay. All right. So what is your answer then to my question?
Can you ask me again? I'm sorry.
Did you ever at any point in time bring to my attention your belief that this ex parte transcript was inaccurate because it was incomplete?
No.
Okay. Why is that?
Well, because of what I kind of just said, I don't
Okay.
believe that it was incomplete per se,
Okay.
minus the off-the-record conversation, but there are a lot of off-the-record conversations that are had that are not included in transcripts, and that's not unusual. to me.
Okay. All right. So you don't actually believe it's
So she's getting down to the fact that there's nothing bad or wrong or incomplete that makes this some kind of violation. So any of the winks or nods or insinuations, all of that kind of goes out when she's saying, no, it was fine. Like, even though it was technically incomplete, it wasn't, some nefarious thing.
inaccurate then.
No, I just think it's missing the off-the-record conversation. I'm not
Okay.
missing. I just think that the defense did not have knowledge of the off-the-record conversation.
Okay.
Not that it's missing from the transcript per se.
Okay. Because it was officially off the record. Is that what you mean?
Yes, Judge.
Okay. And did you ever, if it in fact occurred, did you ever object to it being off the record?
No, I didn't.
Okay. So at some point you brought it to the defense attorney's attention. Is that how you decided to deal with it?
I had a conversation with the defense attorney. I don't want to say I brought it to them, but we just had a conversation
Okay.
about what happened.
All right. Ms. Love, do you have other questions for Ms. Bumpus?
Ms. Bumpus, did you tell any member of the defense about the details of the content of the off-the-record conversation that you had with Ms. Hilton on June 10th?
That I had with Ms. Hilton and Mr. Copeland? Yes.
When did you tell them?
The same day.
Did you tell them everything you remember about it?
I told them everything I remember.
Do you remember how long after the conversation took place it was that you told them?
I don't know, maybe like an hour.
Was court in recess or was court in session when you told them?
Court was in recess.
So this is getting to, was she the source that, Glanville obviously thought she was the source. And while she's admitting she did talk to them an hour after this, she keeps saying, I'm not saying I brought it to them or she was the source. There may be some other way that they found out about this stuff, but this is at least somewhat of an answer that she was one of the people that gave the details to the defense.
Between the time that the conversation between you, Ms. Hilton, and Mr. Copeland ended, and the time that you told defense attorneys all of the details you remember about the off-the-record conversation, was court in session at any point?
I'm sorry, can you repeat that?
Was court ever in session between the time that you finished your conversation with Ms. Copeland
Mhm.
and the time you told defense? what happened in the meeting?
Yes.
Court was in session during that hour?
Had court resumed?
Correct. Did court at any time resume from the time that you left the meeting in chambers to the time that you had a conversation with defense? Just in that moment, from chambers, conversation with defense?
Oh, no.
Court did not resume.
All right. Anything else you want to add before we move on to the next?
No, also though, it's interesting the judge specifically asked her, did she object to the fact that that defense counsel wasn't there? And she said no. This judge is hinting that she really wished that Ms. Bumpus had done it a different way or done a better job.
Or that at least somebody would have to, agree. If you thought it was a big deal that defense counsel wasn't there, then why didn't you say anything? That would have been the time to say something.
Right.
So now we're up to attorney number 2, who's going to come proffer some evidence from the podium, and we'll listen to what attorney Melnick has to say. Nina said, can Woody say to every question and start with, I don't recall, or answer, I don't recall? Theoretically, yes.
If it's true.
But they're not, what?
If it's true.
Right. And it's hard to prove whether or not it's true if somebody remembers something. Olga, I didn't think that the judge and whoever is testifying were allowed to physically face or address the judge during testimony. So this isn't in front of the jury. This is a hearing. The judge is allowed to ask questions. The judge is the one making the decision here. The judge is trying to figure out and get the foundation for what the facts are and what actually happened. So they talk directly to the judge sometimes in hearings and situations like this. All right. So here's Melnick. Let's hear what he has to say.
Of just say that, I think it goes without saying that people can perceive the same thing in different ways, depending upon the perspective they're standing at the time. And I'm going to permit you to make a brief proffer of what you believe happened. I do not think, based on what I have reviewed, that you were laboring under any conflict of interest. I don't even know that at this point in time, any of that is particularly relevant, but I can understand you wanting to put something on the record. I would like for you to stick to the facts to the extent you can, keep emotion out of it, and go ahead.
So, Judge,
You just
basically what
stop
it
it
comes
there
down
for a
to is
second.
after receiving the transcript.
I think that everybody understands what she's referring to. It says, I don't believe you had a conflict of interest. What she's referring to there is saying, I don't believe that you were working for the defense when you were advising Copeland, because that's what the state's alleging is he had a conflict. He was doing the defense's bidding while he was advising Copeland. And she is saying, I don't believe that at all. And I want you to understand, I don't believe it. So she's giving him a clean bill of health on that.
Emotion out of it, and go ahead.
So, Judge, basically what it comes down to is after receiving the transcripts from the 2 ex parte hearings that took place, or ex parte meetings that took place between Judge Glanville and the district attorney's office, and then with Ms. Bumpus and Mr. Copeland in tow, the allegation has been made that I was somehow acting in conjunction with Mr. Steele and Mr. Shart and other members of the defense team in this case, which is categorically untrue. I am unfortunately in a difficult position as it relates to this issue, because what I would need to produce from a documentary standpoint to rebut these allegations are privileged communications between myself and Mr. Copeland. But my presence, so starting with June the 6th, I sent an email to Ms. Hilton, Ms. Love, Mr. Steele, and Mr. Shart stating that Mr. Copeland wanted to take the fifth, did not wish to testify. On the 7th, I was shown an order that was signed on June the 7th stating that Mr. Copeland was being given transactional immunity. At no point, and I think what really bothers me is that at no point did anybody from the DA's office before that time, within any relevant time frame, reach out to me and just ask me if I was representing Kenneth Copeland for purposes of his testifying in this trial. Everybody in this room that has been involved in this case from the beginning has known that I was representing Kenneth Copeland.
All right, and I know because you had a case before me
With Mr. Copeland.
with Mr. Copeland that resolved in June of 2023. So I know that as of that point, you were representing him.
Yes.
And then following the resolution of that case, he did not have any more pending charges.
He did
correct?
not, that's
Okay.
correct, yeah.
All right, so that was a year ago.
So at a minimum, I feel it was incumbent on the district attorney's office to reach out to me just to ask that question. Now, as far as what communications took place between the DA's office and Mr. Copeland, I don't know exactly. But I do know that on June the 6th, he and I spoke, and he told me that he wished to assert his Fifth Amendment privilege. And so I sent that email. The transactional immunity order was granted on June the 7th, which I find the timing there to be, let's just say, ironic, in that apparently they were going to have Mr. Copeland testify without any grant of immunity because it was the state's intended purpose to call him as a witness on June the 7th. And so I was here on June the 7th. I told the court what Mr. Copeland's intentions were.
Which I will say that's not unusual. What they grant immunity after they find out you're going to plead the fifth. That happens all the time. But he's trying to, I mean, in that sentence, it's kind of like, I find it interesting that, they didn't plan on giving him immunity until he said that.
Yeah. Also, if make sure they count, she was Copeland's judge when Copeland had a separate case that Melnick represented him on. We have the same judge.
There was a lot of back and forth. Obviously, Mr. Copeland was taken into custody on June the 7th, and then everything that happened on June the 10th. I don't have to go over all.
Yeah, I've read all of that.
Yes. So my purpose here today is to state on the record that absolutely, nothing that I said or did on Mr. Copeland's behalf was done in any conjunction or with any consultation, in cahoots, or anything along those lines with Mr. Steele or Mr. Shart or anybody else in the defense team.
All right.
I was here doing what my client had expressed to me, what he wanted to do. And as I said, if it becomes a major issue, I have more than enough documentation to prove that.
Okay, I appreciate that.
Mhm.
It's not an issue at all to this court.
Okay.
All right, thank you.
All right. That's it.
So she basically cleared him after that proffer. And he says, there's a lot more I have that nobody has seen that's protected by attorney-client privilege. But if the accusations really keep flying, I'll bring it out. And then everybody better be ready for the truth.
Yeah, everybody should understand too, that's listening. We're only showing them short clips. He was actually questioned and cross-examined by the prosecutors after this. I mean, he didn't waver and the judge didn't change her opinion, but he went through cross-examination by Miss Love after he made this statement.
All right. This next portion that we're going to listen to, I believe, is Copeland on the stand. So what they're doing here is basically the judge determined we're going to redo the ex parte hearing in front of all the defense team, going to try to cure that defect if they have any questions so everybody can know. And that she said she had to correct some inaccuracies that happened in the ex parte hearing, which will point out some of the differences in what she explains to Copeland and what we remember from the ex parte hearing.
Right. This is kind of her way. It's an indirect stick in the eye of Judge Glenville in that she is now redoing theoretically the explanation of what immunity is, all the things that this hearing, this ex parte hearing was supposed to do. She's going to redo it in front of everybody now so that there's no question about the explanation and what Mr. Copeland will or won't do or does or doesn't understand.
Right. And I think that she's also proving it did not need to be ex parte.
Right.
Because we basically do it right here in the open.
To do this, but I object to counsel for the defense.
I've asked them to raise anything that they think we ought to be thinking about. So, I invited them to say that. So I don't know whether you want any additional time, having heard that potential issue, Mr. Melnick.
Mr. Copeland and I have had enough time to talk.
All right. There, some attorney, Mr. Melnick, is with us by Zoom right now. You can see him on the video screen and he can see you. If there's any time you want to talk to him privately, let me know that. And I know y'all have had an opportunity since you and I spoke this morning from the bench in the stand to talk about the fact that the state is not interested in you pleading the fifth. And in order to avoid you pleading the fifth, they have secured an order that says you now can be essentially compelled to testify because we are acknowledging that anything that you say, we cannot prosecute you for a crime other than perjury or false statements based on something that you might say that would otherwise incriminate you if it weren't for this immunity order. And if knowing that you still choose not to testify, the court can and will hold you in contempt. And what happens in that event is that you go to jail. And the length of time that you could be held in jail for, if you don't change your mind and say, okay, I guess I will take the stand, is through the end of this trial. I don't know how long it's going to last. I think previous projections had been February or March of next year. I don't know yet, but I guess that's not outside the realm of possibility. But it would only be through the end of this trial. It would not be through the end of whomever else might be severed from this case and tried later. And I know Mr. Melnick's talked to you in more detail about that. So I want to see if you have any questions of the court about that.
I didn't understand. Now you said at the beginning.
Didn't understand anything. All right. So
No, I'm saying, like, I heard you, but I don't know what you're talking about.
okay. So tell me what it is that you'd like more information about.
You said something about what they said about immunity?
Yeah.
What you mean?
Okay. Does anybody, I think I've got the order. Mr. Melnick, have you reviewed the immunity order with him?
Oh, you saying it's the same from last time?
Hang on a second. Yeah. The same one as last time. Yeah.
Yes.
That one. So that's the one I'm talking about. And that is still in effect.
So you're saying that changed?
It has not changed.
All right.
So what has changed is it's my opinion that I cannot hold you in jail if you refuse to testify beyond the end of this trial. I think you had maybe been.
So that's one of the differences she's going to point out is that Glanville, and the prosecutors basically said you can be held in jail this trial and all the other defendants could be years and years and years. laying these huge threats over his head. And she's like, I think I can only hold you in jail for this trial until you refuse to testify in those other trials, which she's probably right. And so that's the first correction of many she's going to make. That was added pressure, coercion, and threats being made by the judge and the prosecutor when the defense attorney was not there.
She also correctly stated the law that Glanville did not. Remember, Glanville said, I'm going to put you in jail, you're going to stay in jail. Then you're going to, whether it's criminal contempt or civil contempt, and she correctly stated the law. You go to jail, you only stay there as long as you want to, you have the keys to the jail cells, the way we refer to it, and that if you decide to testify under immunity, then you can get out of jail. So she made a correct statement of the law as well when she was trying, tell him what's going on.
Told something different earlier. And I don't think that is
So I ain't got to wait
accurate.
till every defendant is not here.
Correct. But you would, if you choose not to testify despite this order, you would potentially be held in jail through the end of this trial, which might be February of next year, might be March of next year. I really don't know. It ends when it ends. And the state has 100 more witnesses, and I don't know, any defendant might also have witnesses. So it could take a while, but that would be the end of it, would be the end of this trial. Okay. So do you have any other questions? Okay. Do you want to talk to Mr. Melnick any more about this particular issue?
No.
All right. So I'm going to ask you right now, because I'm planning to have the jury back on Monday. And I am going to tell them, we would essentially start over, because I want you to have a voluntary, to an extent.
So when we talk about starting over, I know there was talk about her wiping all of his testimony and redoing it all. Is that what she's going to end up doing?
She has already issued the order saying that starting with June 12th, everything after that's gone. That they have to redo everything after June 12th. She entered a written order. Now, I'm listening to her, and I think she's thinking, I may expand that order to have Copeland start from the beginning. That may happen, but she has issued at least the one order. Actually, she's issued several orders in this case already, but that one was starting June 12th, beginning June 12th. Everything from June 12th on is history. All has to be redone.
How in the world can you possibly expect a jury to follow and understand what's going on and why? Hey, guess what? New judge. Hey, guess what? We're erasing everything that's happened for the last 2 months and we're starting all over. Hey, Mr. Copeland, let's do this again. Jury, magically wipe what's been in your mind from 2 months ago, which has probably already been wiped because they have lives and real life issues probably going on with their families and their friends and their jobs. And then they got to come back in here like the Men in Black mind reset thing. Like, this makes no sense that they would do this. It is so confusing, which is something that we try so hard as lawyers not to do. And this is the position they're putting this jury in. How in the world are they supposed to remember what the heck happened at the beginning of this case?
She's asked everybody to draft some jury instructions.
It's crazy.
To tell the jury, but you can tell, it's her intent to finish this trial.
That's what it feels like, but she makes some comment in another clip that we'll see.
Choice and knowing choice, whether to take the stand and be questioned and cross-examined or not, knowing that if you do, other than if you lie, as Mr. Melnick's discussed with you, and it's something the state knows and can prove, they can charge you with perjury or false statements, but they can't, if you incriminate yourself about another kind of crime, they cannot use that to charge you with a crime. And they can't say,
Well, can I speak?
You can,
I
yeah,
have
if you
told
have
the
a,
state,
huh?
I have told the state I have lied and lied and lied and
I
lied.
know. And
So how are they going to be able to question me?
I mean, that'll be their problem. That's their case to make or not make. I mean, that's not.
He's like, yeah, I've told everybody I lie. How can you even question me at this point? He's making sure everybody knows that.
For you or me to worry about. So
They say they're going to be able to charge me if I lie. Like, when they, it's up to them to choose when I'm lying.
not prior. You've said you've lied in every, I don't know what you've said, but let's even say you've said you lied in every statement you ever gave to the police. If you get on the stand and say that again, or if you say, all right, this one was the truth, that one they cannot charge you with perjury for, because those are things in the past. What they might be able to charge you with is, I don't know. I mean, give me an example of something that he didn't do, and well, maybe not. Never mind. Don't do
Can I give you an
that.
example for what they told me?
Yeah.
Don't give an example. Although what that did, just her asking that question, I think, was a help to Judge Glanville, because trying to look for reasons, maybe he could argue that's what we were doing, and they knew he didn't commit this crime, so that's why they used that as a reason to try to explain this to him. But she almost did kind of a similar thing there, which I thought was kind of funny.
Yes. And then I'll see whether that's what I think or not. Yes.
So she said that the only reason she won't lock me up, I just want to know if it's still a fact.
Okay.
She said if I do two things, if I plead the fifth and I said that I killed Donald Thomas.
Okay.
She said, if I don't say them two, she will not lock me up.
All right. What was the first one?
Pleading the fifth.
Say it again.
Taking the fifth, Judge.
Taking the fifth. Okay, right. And you can no longer, so taking the fifth means I might say something that gets me in criminal trouble. I might give you evidence against me that you can then use against me. That's what it means to take the fifth, is say, I am not going to give you evidence to use against me to charge me. When they give you that immunity order, immune just basically means we can't do this anymore. It's like if you get an immunization, oh, I'm not going to get the measles now, right? Because I'm immune from it. Because it's like getting you a shot that says, I can admit to a crime on the stand, they can't charge me with it. They have said, you no longer have a privilege against self-incrimination because we have committed to not being able to prosecute you, not being able to bring criminal charges against you because of what you say. We cannot take that evidence and use it against you. We can't take that evidence. If you say, well, I committed some crime, here's what I committed it with, I buried it in the yard. They can't go dig it up in the yard and then say, well, we've got this. They can't use any of that. So that's why taking the fifth at this point would get you in trouble. Being held in contempt is what we
So what if they don't
formally call
have
it.
they facts together? Like they saying something they don't know what they talking about, and then they ask me about it.
They can ask you about anything they want to. If in your answer you admit to a crime, they cannot charge you with that crime. Now, if you admit to a crime and they have evidence that is pretty certain that you did not commit that crime, for instance, somebody gets robbed yesterday and they have proof that you were in Europe yesterday. There's no way you could have committed that crime, but you say, yeah, I committed that crime yesterday. That was here in Atlanta when they know you were in Europe and they got video of you in Europe and you sent a postcard that said, I'm having fun in Europe. That would be proof that you're lying. And so that they could charge you with perjury for, okay? Or false statements for.
Okay.
Okay. So what I want to know from you is when we have the jury back on Monday and you're still under subpoena, so you're still obligated to come in. I'm asking you now, when they're like, all right, we're calling Kenneth Copeland, are you going to say, okay, ask me what you want to ask me. I'll tell you whatever I'm going to tell you. Or are you going to say, nope, I don't care if you throw me in jail. I'm not saying a word. I'm not getting on the stand.
It depends on how I wake up.
Okay. All right. Well, then we will just revisit it on Monday morning. So plan to be here at 8:45 on Monday morning. You're free to.
It depends on how it goes. So we have no idea if he's going to plead the fifth on Monday or if he's going to answer and just say, I don't recall, I lied, et cetera, et cetera.
It's great. I mean, I love the fact I've never had a witness that says, I lie all the time. You can't believe a thing I say. So, I mean, how are they going to sell this guy to a jury when the cross-examination is going to be, do you lie all the time? I lie all the time. I mean,
Did you lie during direct? Yes.
I lie every time. I always lie. I'm a liar.
Crazy. It's crazy. Nina said, Papa T, do you think the state knew Woody was represented by Melnick, or did Woody fool them?
They knew he was represented by Melnick in 10 different ways. Once they had those emails, they got emails from Melnick saying my client's going to take the fifth. They knew that, and there's court records that show Melnick represents Woody in the court file. So there's no doubt in my mind they knew that.
I think she's asking about prior to that, and I think they have like plausible deniability, but it's very obvious with a very simple search or very simple questions to find out that he was represented. I think there was some willful ignorance there. Art and Gray said, can a juror say, okay, now I can't be impartial anymore? So this is a good question. And I mean, neither of us have ever dealt with anything quite like this. I don't think any lawyer has, but like you come after a long break, everything is different. Like jurors reasonably could be like, okay, too much has gone on. I just can't believe anything the state does anymore. Do you think that would be a legitimate reason to let him off the trial?
Sure. That absolutely would be.
Could happen.
Yeah, because, same thing. I watch TV and I saw this on TV. You're off the jury. I have an opinion now. You're off the jury. So I think that's a legitimate statement. And I think that could cause a juror to be excused.
Sarah says, hi, Peter and Mr. Tragos. Why no mistrial? Chat wants to know. Silly question, but what about defendant's right to a speedy trial? Yeah, well, the speedy trial question, unfortunately, is once you get in trial, speedy trial is kind of gone because it's just basically starting the trial. But why no mistrial at this point? I'm going to get the next clip kind of ready and queued up to go. But why do you think at this point the judge is not declaring a mistrial? And let's save till the end whether or not like we agree with that. We'll kind of break that down at the end. But why do you think, based on what this judge is saying and doing, that she has not granted a mistrial at this point?
She has a duty to have a jury make a decision based on the facts of a case. And that's the real duty. Mistrials with prejudice are only rarely granted under certain special circumstances because the law wants jurors to make decisions on the facts. And so that's what she's trying to do, even though it is hard, but you can tell she's trying very hard to make decisions on the facts. Well, go ahead, because I know we're going to have another clip. So.
Well, yeah, but I also want to talk about mistrial without prejudice, letting the jury or letting the state refile. Obviously, the defense is going to file all their double jeopardy motions, but that is an option for the court at this point as well. It's too mucked up at the fault of the judge, maybe not the state. Mistrial without prejudice, neither side's fault. State, you can go ahead and retry the case, and we can talk about why not for that with the resources and time and money that's already been spent. But again, we'll answer all of those kind of questions wrapping at the end. This is the last clip we're going to listen to.
States that in the center, and we have previously held that trial courts may disqualify attorneys for violations of the disciplinary rules. We held that the trial court erred in ruling that because sanctions for violations of disciplinary rules appear to be the exclusive province of the Supreme Court of Georgia, not of the trial court, it lacked authority to determine whether plaintiff's counsel violated Rule 4.2 of the Georgia Rules of Professional Conduct, and therefore should be disqualified. We noted that the determination of whether an attorney should be disqualified from representing a client in a judicial proceeding rests in the sound discretion of the trial judge. So I'd just like you to reconsider your order, not disqualifying Ms. Hilton and Ms. Love. And you've inherited a case that has a lot of history and a lot of it bad. And I put into my motion, I can go over it with the court, and I also attached the YouTube links. It's on July 10th, 2024. I also filed in case the link goes away, I filed on a thumb drive to preserve it. So that's with the clerk's office, and a copy was sent to the prosecution as well. But it started before, but an opening statement, I don't know if you read it. So
I read your motion and I looked at the portions that you were talking about.
it's hurtful. And then as of last week, a new court comes on. It's almost like, a breath of fresh air. It's all new. And again, I'm hit with a motion by Ms. Love that was the fourth time the same thing's argued. It's talking about a duty that is intentionally and knowingly not followed through by me, and I owe it to her. And I saw your email saying, whoever wrote that, you come into court. I understood it.
I don't think Ms. Love did herself any favors with that.
Well, the favors have to end. I'm not trying to, I've never done this before in my history of living in a courtroom, but it's just not appropriate that I can't accept a proffer from a lawyer. I've never said that before. I've never uttered.
Why don't you explain those last two things that were just said about the email and how the judge said Ms. Love didn't do herself any favors, and then why he's making such a big deal about not being able to believe a proffer from another lawyer.
See,
and how unusual that is.
Sure. We were talking about this. In fact, we talked about in the last clip how you can't have a conversation and trust what the other lawyer is saying to be honest with you and to tell the truth. Sometimes you can't talk to a lawyer unless there's a court reporter present. You won't talk to him on the phone so you want everything in writing because you just can't believe that they're going to say the same things twice. What he's saying is they basically lie. They lie to him. They lie to the court. We haven't, we would be here forever if we showed all these clips. There's a clip where the judge actually tells Ms. Love while she's arguing, Ms. Love, I looked at those two cases that you cited. They don't say what you say in the motion. And
I don't remember Glanville doing that ever. I don't ever remember him doing something like that when the prosecutors made arguments.
Right, but she has. And she told Ms. Love, you misquoted the case. And Love, well, it was a mistake, a typo, that kind of thing. And she goes, where in the case does it say that? Well, Judge, this is just a typo. I just made a mistake. And she specifically said, Ms. Love, you need to show a little more candor to the court, which basically means you need to be a little more honest with the court, because she's indicated that she cannot believe Love now when Love files a motion and Love says, there's a Supreme Court case that says this. Ms. Love, I can't believe you that there's a Supreme Court case that says this, because over and over again, you've lied about what the case says. And the four motions he's talking about, this is a work product motion where prosecutors are never allowed to see a lawyer's work product. It's privileged, no work product. She has filed the same motion 4 times, even though it's been denied by Glanville 3 times. So she files it again with this judge. And that's when the judge is saying, you didn't do yourself any favors. Over and over again, the feeling I'm getting is that this judge has a negative impression of Miss Love and the prosecutors. They have not ingratiated themselves to her. For instance, another thing, they asked for a limitation of witnesses. Tell me how many witnesses you're going to call. Give me a limited witness list so the defense can be, prepared for the cross-examinations. The list they gave her still has over 100 witnesses. We know they're not going to call over 100 witnesses. The judge knows they're not going to call over 100 witnesses, but the state won't give anybody an honest answer about anything. So again, they just keep shooting themselves in the foot. And this judge is going to stay calm. She's going to smile. She's going to tell a couple of jokes. She's going to laugh with everybody, try to keep things light so they don't scream at each other and yell. In fact, she gives a speech about how you've got to stop calling each other names and saying bad things to each other. But in the back of her mind, you can see she's angling it toward the prosecutors because of what the prosecutors have been doing in this case.
Yeah. I mean, I can't blame her for not, having a positive impression of them. I think they could fix that. I think she'd be open to letting them fix that. But even if you look at some of what was argued today, there were phone numbers and names potentially and search warrants and affidavits and all sorts of things the defense didn't know about. The state still hasn't turned over. We're months into the trial. We're years into the case. And she had to ask the state today, is there any other Brady information that you guys have not turned over? And Ms. Love couldn't answer. It's like, how can you not answer? We're in the middle of trial. And if the answer to that is yes, shouldn't this case be over? And Azam asked Peter and Big George, what do they do if they knock out most of the jurors? Do they need to do jury selection again? If so, is in a retrial. If they lose too many jurors, it's going to be a retrial for sure. It's a mistrial. Yeah. And if they lose because of something that's attributed to the state won't be able to refile charges. So the state's got to be careful about how all this goes when it comes back.
Now, another thing that she's done is she has issued an order on their first motion to disqualify the prosecutors, denying the defense motion for the exact reasons we said a little while ago. Was the fact, number one, it's an extreme remedy to be able to call the state as witnesses. Secondly, only if you can't get the information another way. And since there were so many other people in the room that could testify, the judge said, you don't need to call the prosecutors as witnesses. Therefore, I'm not going to disqualify them. Because of that, he has now filed that additional motion to disqualify that adds other grounds besides the fact that we need them to testify about the ex parte hearing.
Mm-hmm.
Any of those words. So I'll leave it with you. My point is, it doesn't end. There have been no sanctions. It's been ratified almost. And it's from everything. It's just, I put in paragraph 2, just choice examples from my memory, but it is constant. There are great people everywhere in the courts and they shouldn't be treated like this. So that's I'm asking you to disqualify because it's just not, at some point, the message needs to be sent that this is not the state of Georgia and this is not our bar.
All right, thank you. As I understood the gravamen of your motion that you filed since I've been the presiding judge to disqualify Ms. Love and Ms. Hilton, it was because you needed them as a witness, and that was the basis of my ruling. And in Mr. Sharp's motion that is under consideration right now is a request, again, to disqualify them. And I know that I previously said, y'all, that's a matter for the bar. And when I was talking about that, I essentially meant and I don't want to call it bickering back and forth because I'm not sure it's been back and forth to any large extent, but that kind of thing, whatever it is that had been talked about before, that's what I was talking about. I will tell you that this court takes Brady violations very seriously. And I mean, everybody ought to, prosecutors ought to.
So here's her little hint at the end of this video. That's important, I think.
This court takes Brady violations very seriously. And I mean, everybody ought to, prosecutors ought to, and I am considering that right now. So rest assured that I am aware and have been aware that I have the authority if I choose to remove them.
Thank you.
So, all right.
All right. So she does have the authority. She wants to make sure everybody knows that. Why don't you answer Scarlett real quick about what's work product? I'm going to put up, there's one more short clip I want to play.
Work product is what a lawyer, let's say I sit down and I talk to a witness and I take notes about what that witness says in order to keep my mind fresh about what they say. That's work product. That's something that my mental impressions of something I put down on paper. They're not allowed to see my mental impressions.
It's protected. Yeah.
Yeah, it's protected. And that is work product, my mental, or if I decide, okay, this is my order of evidence I'm going to put in. That's my mental impressions. They're not allowed to compel me to tell them what I'm thinking and how I'm thinking.
Jilly May said, so what's going on with Glanville at this point? Is he facing penalties or consequences? At this point, he's just recused from this case. He could still handle other cases. Your mom's new accountant said, question for Peter in chat. Can we cover the NV Vitellas out of Vegas? Public admin accused of ending the life of a beloved journalist after journalist did articles about corruption in his office. Jury selection starts Monday. I've never heard of it. Don't know anything about it. If you guys want to cover it, let me know in the chat and on social media. That's how we pick the content on this channel. Let's listen here to this 39-second clip about how Miss Love deals with an objection, the defense saying that the state didn't turn something over. It was a Brady violation, and the defense knows because they found that evidence. This is what she thinks about that and how she thinks Brady works.
My understanding of what Brady is that it is information that is not available to them by any other reasonable means. And they had someone telling them something about what was going on. So it's not a Brady violation if they had access to it. If there's a different argument, a different issue that we're going to be arguing, I'll hear that from the court. But as to the Brady violation, my argument is that, and
so that's her thought on Brady violation. Midnight, we're pumped you're here. Very happy you're here, and sorry to the loss of your grandmother. 91 years, long time. That's awesome. So what is your thought of her explanation of Brady? Well, if the defense never finds it, they don't ever find out about it. So therefore, they never even know it exists. So no harm, no foul. If they do find it, then they obviously had access and other means to get it. So no harm, no foul, no Brady violation. So the state never has to turn over anything because the defense can access and get everything themselves, right?
Well, we've talked about this many times. Brady duty is on the state. They're the ones that have a duty to turn over this information. And the fact that it may be out there somewhere doesn't obfuscate their duty. If they know about something that can be used for impeachment or that goes to the innocence of a client, they have a duty to turn it over, not just to sit back in the middle of trial and say, oh, well, we didn't turn it over, but that's okay because now they found it.
Yeah, that defeats the entire purpose. It'd be one thing if it's like the defendant's cell phone is Brady. It's like, okay, the defendant has his phone, maybe that's a little bit different. But I honestly, it's just so wild to me that she would even make that argument in open court. That alone would frustrate the crap out of me and make me think she's got to go. Judge, if that's how she defines Brady, now we think, I guarantee there's stuff we don't have. Because if we don't have it, she's not going to tell us we don't have it. And unless we find it ourselves, we're never going to find out about it. And if we find it ourselves, she's going to say, good, that's how it should be. You obviously had access to it.
Who in the world, what listener, what person following this trial would believe anything Miss Love says? I mean, who in the world would trust her to abide by the Constitution and all the protections the Constitution gives to defendants? She doesn't care about that.
She made it clear.
She only cares about a conviction, regardless of how she gets it. And everybody understands that.
Yeah, she made it clear. So final thoughts on, do you think there'll be a mistrial? Do you think the prosecutors will get booted off the case? What do you think? How do you think this is going to result?
Well, interesting. I can tell you statistically, there won't be a mistrial. But there are a lot here for a mistrial. And there are things that we don't control. For instance, that question that one of your listeners asked about the jurors, that's something that really could come into play here if these jurors come back from this long break and have some issues and they end up getting knocked off the case. The Brady, like you said, she kind of telegraphed a Brady issue. That Brady issue could result in a mistrial. And that could be a mistrial with prejudice because it would be something that you could blame on the prosecutor. And the courts may say that means it's with prejudice and they can't be retried. So you got the Brady issue. I don't think she's going to.
Francis is asking to explain what a Brady violation is again. So it's same thing that happened in the Baldwin case, but a quick explanation because I got to run here. I'm already 4 minutes late for my last.
Brady means if the prosecutor knows about something that you can use to impeach a witness or that goes to the innocence of your client, they have a duty to turn that over and tell you about it. That's the simple explanation. It's a U.S.
They have to give you exculpatory information or else it's a violation. They have to do that. But overall, so do you think mistrial? Do you think they'll get removed?
I don't think, I think the case is going to go forward. I think that they're not going to get, I don't think they're going to get removed. I think this case is going to go forward. The appellate court may chew it up, but I think it's going to go forward.
I kind of think if they were going to get removed, you might as well just grant the mistrial at that point. If you're going to remove this prosecutor's office, how the heck can we keep going forward? So I think it's either going to be 2 yeses or 2 nos. And from what we know right now, I agree with you. I don't think there's going to be a mistrial. I don't think they're going to boot him off the case. But like it sounds like you're saying, and like I'm listening to some of the hints the judge is giving, if this gets worse or continues, I think this judge would do it. I think if it gets worse or something big does happen and she finds a huge Brady violation, I think she would throw this entire case out.
Well, she has a bad impression of the prosecutors now. There's no doubt about it. And if this keeps going, she's going to chew them up.
Charlie said, please give this to young George in his excellent, gracious front officer duties. I will definitely do that, Charlie. Thanks for stopping by the other day. It was good to see you. Ranger fan, I sent Vegas journalist to you on Twitter. I saw your tweet that said this is something different right before I came on, so I wasn't able to read it, but I will look into it. So I appreciate you guys giving us the content. I appreciate you joining me. Please hit that like button. I don't think I've said that throughout this video. Make sure you hit the like button. Make sure you subscribe. Until next time, we are out of here. Peace out. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a uase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.